So, picture this. You fought a legal battle all the way to the Supreme Court, and they say no. You lose. For most people, that's it, end of the line. But what if that no wasn't the end? What if it was just the start of an even bigger fight?
And that's the big question here, right? Why on earth would a company, after getting a final no from the highest court in the country, just turn around and knock on the door again? It's a super rare move, and it really only happens when something has just completely changed the game. And trust me, it has been a rough ride for them. Just look at this timeline. Rex files the lawsuit back in 2021. A lower court tosses it. The Court of Appeals agrees. They take their shot at the Supreme Court, which also denies them, and yet here they are, filing a second time. Something huge must have happened to make them think this time would be any different. Okay, before we get to that, let's get a handle on who we're even talking about. In one corner, you've got the challenger, Rex, that's real estate exchange. And in the other corner, you have the industry giants, the National Association of Realtors, NAR, who created the rule at the center of all this. And of course, Zillow, the tech behemoth that actually put the rule into action. This entire crazy multi-year legal drama with millions of dollars on the line, it all comes down to a single rule. And the wildest part, on paper, this rule was completely optional. Nobody had to follow it. So the rule is called the no commingling rule. It was an optional policy from NAR that basically told multiple listing services, hey, maybe don't mix these different types of listings together. Zillow went along with it and redesigned its website, which ended up shunting Rex's listings off to a totally separate tab, where no one would see them. Rex says this absolutely crushed their business and was a textbook antitrust violation.
And that right there, that's the million-dollar question. It's the legal puzzle at the heart of this entire case. If nobody's forcing you to follow a rule, if it's just a friendly suggestion, how can it possibly be part of an illegal conspiracy? Well, Rex's answer is a legal idea called concerted action. Basically, they're arguing that it doesn't matter one bit if you slap the label optional on a rule. If a powerful group like NAR puts it out there and all the big players like Zillow fall in line, it has the exact same chilling effect on competition as a mandatory backroom deal. It's coordination without the contract.
So that's been their argument this whole time. And as we saw, the courts, all the way up to the Supreme Court, weren't buying it. So what gives? Why go back with the same argument? What's new?
Well, they're playing a real legal long shot. They're claiming something called an intervening circumstance has occurred. This is a huge event that happened after the Supreme Court said no the first time, an event so significant, they say, that it changes absolutely everything. And this is it. This is the bombshell. After the Supreme Court denied Rex's case, a different federal court in a different part of the country ruled on a similar case and came to the exact opposite conclusion. And it created this, a perfect 3-3 split among the nation's circuit courts. 3 circuits say, yes, an optional rule can absolutely violate antitrust law. And 3 say, no way. The law of the land is now literally split down the middle. And that is Rex's intervening circumstance. They're going back to the Supreme Court and saying, look, this isn't just about us anymore. This is now a matter of urgent national importance. The country's legal system is in total disagreement, and you are the only ones who can fix it. And this is where the story just explodes beyond Zillow's website. According to Rex, this case has accidentally uncovered a massive loophole that could undermine all of U.S. antitrust law, affecting every single industry. In their petition, they start with the immediate stakes. They say, look, a ruling for us would blow open competition in the gigantic multi-trillion-dollar real estate market. So that's big enough. But then they go even bigger. And this quote just perfectly lays out their fear. They're warning that if this stands, any powerful industry group can just create optional rules that are really just a wink and a nod, a secret handshake for companies to illegally coordinate, all while claiming they didn't have to do it. It all builds to this one final, truly staggering warning in their legal filing. They argue that if this optional rule loophole is allowed to exist, it won't just hurt real estate. It could lead to resetting the structure of the entire U.S. economy. I mean, that is a huge claim to lay at the feet of the Supreme Court. And so that's where things stand. That one little word, optional, has now created this fundamental crack in American law. And it leaves us with this huge question.
Could a quiet, so-called suggestion in just one industry really create a playbook that changes the rules of the game for the entire American economy? The Supreme Court now has to decide if it's finally time to give an answer.